Condominium Law Group, co-hosting today with Ken, who I'm sure you all know. Before we get started, I would like to just go over our disclosures and disclaimers. This uh, this this session isn't our Zoom Q&As are not intended to provide legal advice. We are here only to have a general discussion around these topics. Please also understand that the chat function is not intended for questions or requests for clarification. Commentary in the chat is not to be considered legal advice. We also request that you mute yourself during this session so that we are not interrupted unnecessarily. We wanted to give you a couple of dates that we're looking ahead to. The WSCAI annual conference will be this April 9th to 11th. I believe it's at the Seattle Convention Center again this year. We look forward to seeing hopefully many of you there, as well as a scheduled virtual law day, which I believe is on June 9th this year. So those are two events we look forward to and hope to see you at. And we will be getting started with the first question. First question is, the manager has stated that he has a general legal question for you regarding a problem tenant. The tenant is renting an owner's unit, but comes to every board meeting with issues and complaints, and has previously voted regarding certain issues with the association. Does the board need to humor this person, or does their vote even count, considering that they are only a tenant and not an owner? So, given the new open meeting requirements and to have an open comment period at the start of a board meeting, there's no reason not to allow a tenant to have the same 90 seconds as any registered owner. That being said, we would not recommend that you allow a tenant to vote unless you have something in writing from the owner assigning a proxy to that tenant. Another caveat would be that an owner's representative is allowed to attend meetings. So you could ask the owner if this person is representing them, this owner, and if not, the tenant can be excluded from the meeting. And if yes, a yes would allow them to qualify as a proxy. So another idea is you could try asking tenants to submit all of their concerns through the unit owner. And that way, again, if depending on what your CCR, what your governing documents say, that would also be another way to sort of channel these questions through a more clear proxy. Also be aware that the statute does allow any attendee to be removed from an open meeting. So specifically, the statute says, WUCIOA states that meetings must be open to the unit owners except during executive sessions, but the board may expel or prohibit attendance by any person who, after warning by the chair of the meeting, disrupts the meeting. So in this case, it doesn't sound like what you're explaining here is the tenant is that disruptive, but if it does escalate to that point, that's always an option for you. Ken, did you have any additional comments on question number one?
Yeah, so the statute which allows you to remove the disruptive person is 6490 445 subsection 2A. That's the one that also requires the meetings be open. We're not certain whether the full board has to vote to expel the person or if the chair can expel the person, but it does require that the person be given a warning by whoever is chairing the meeting. That might be the manager, that might be the board president. It's just whoever's running the meeting. And then I want to make sure people understand there is a difference between a representative of an owner having the right to attend a meeting, and the tenant might be qualified for that. And the difference is between that and a proxy, which would allow a person to vote on behalf of the owner. So you could be a representative allowed to attend, but if you don't have a proxy which meets the statutory requirements of a proxy, then the tenant would not be allowed to vote. So the second question is, please provide information on the new RCW changes as they apply to committee meetings. Is it true that committee meetings must be open to all owners and the meetings must be scheduled with the same notice requirements and timelines as required for board meetings. Also, my understanding is that committees do not make decisions, rather they make recommendations to the board, and the board approves or disapproves the committee's recommendation. So you've got a lot in here. The statute which controls is again in 6490-445, and it's in subsection 2A. And it specifically talks about committees authorized to act for the board. So if you've created a committee that is allowed to take action that would normally be a board action, then all of the same requirements for open meetings, providing comment periods, etc., need to be followed for those committee meetings. If the committee is advisory only, then the committee does not have to follow all those, because the assumption is that all of the discussion about the topics and the decisions will be made at a board meeting where there will be adequate notice and opportunity for comment. So an example of an advisory committee might be a landscaping committee where people go around and make recommendations to the board about what kind of work should be done on the landscape. An example of a committee authorized to exercise board power might be that you appoint a committee of the, say, the treasurer and the president to prepare a budget. And so if you're talking about a budget, that would be something I would normally consider to be a board power. And so that budget discussion should be done in an open meeting. The statutory requirement is still the 14 days. And I guess what we would offer is that the lowest risk option is to just have all the committee meetings scheduled and open, because then you don't have people arguing about whether or not you had some kind of board discussion or not. What I don't want to do is have people try and push board discussions into committee meetings that are private, because that would be, I would say, clearly against the intent of the legislature. Anything you want to add, Tima?
Nope, I don't think so, Ken. The next question. We are a self-managed townhome community without an office or a manager. Do we need to establish a street address? We are currently using a P.O. box at a nearby postal service, but nothing comes there except a random IRS notice, as all contracts and invoices come electronically. We would like to save this cost. Our registered agent is a board member using their home address. How do we establish who and how do we establish where we are? So the short answer to this question is that yes, a street address is required in order to be a registered agent for a corporation. So in order to fulfill the statutory requirement of RCW 2395-410, address and filing, a street address is required for service purposes. But you may also have a mailing address that is different. So in the context of the question that you're asking, we do you will have to have a street address. So what you're doing is correct as far as that's concerned. If for some reason there is a concern or at all that mail getting confused with the personal mail of the board member and the association, you could have a P.O. box and a street address, but the street address is 100% required. So, that's essentially the best way to go about this specific question and answer here. Whether or not you can, whether or not the decision to use the board member's home address as your street address is a decision that is a ministerial act under WUCIOA rules effective January 1st, 26 is unclear, because we don't know if that's it hasn't been defined whether that decision would be a ministerial act. However, to be in abundance of caution, we recommend you would make that decision in an open board meeting. And I think that's all. Ken, did you want to add anything?
Well, something else that just occurred to me is that the association is required to have, I would say, an address which would be the official notice address for owners to communicate with the board. And you can agree to allow electronic notice, but I don't think you can require electronic notice to the board. So there should be an address that if a member of your community wanted to write a letter to the association board, that they would have one address that they are supposed to send it to. And this is certainly something that I'd say most of our clients don't formally do. They've either got a manager who's collecting the mail for them, or the association has a PO box, or the letters are sent electronically. But the way the statute is actually written, there is a requirement to provide an address for notice in the same way that each owner is supposed to provide an address for notice or agree to electronic notice. So I don't know all the particular circumstances going on, but I would say you probably should have an address that if you were to receive something in writing from an owner, just as you might receive from a vendor, that they know who to send it to. Next question. Is our PUD grandfathered and not required to meet this year's UCIA requirements since it started back in the year 2000? And the short answer, of course, is no, you are not grandfathered. Every community association in the state is required to comply with portions of the WUCIOA statute 6490, because that's what the legislature has decided. There's a relatively short list in WUCIOA under section 6490 365. And that list has, it looks like about 10 subsections of WUCIOA, which apply to all communities that existed before today. One section is the ability to elect to adopt all of WUCIOA early, and we've had a number of clients do that. One section is little bits and pieces of the powers of an association. One of them is the power to adopt budgets, and the other is the power to impose assessments on units. The big section right now is section 445, which is about how meetings are conducted. That's where we get all of these things about the open meetings and 14 days notice and committees. That's the one that people are sort of battling with right now. Section 490, 480, subsection 10, there was a new section installed which requires that associations have at least one method for an owner to pay their assessments, which is free. And so that went into effect January 1. Section 502, which addresses emergency powers of the board. So if you were to have a fire or some other kind of an emergency, when an emergency is very precisely defined in the statute, it gives your community some extra powers and eliminates some of the notice requirements. The sections on electric vehicle chargers and heat pumps both went into effect on the 1st of January. The budget ratification section has been in place since 2018 for all communities, and the reserve study portion of the statute has been in place since 2019. And then to the extent you need definitions for any of those parts of WUCIOA, the definitions in WUCIOA would apply. So, don't think because you're an older community, you get to avoid all of the hassle of the new notice and meeting requirements. You get to do it just like everybody else. Anything you want to add, Tima?
Nope, I think that covers it. Question number 5. At owner meetings, like an annual meeting where a quorum is not reached, but some owners still show up and it is announced that the quorum has not been met, some of the owners present want to ask board questions. Should members of the board engage in discussion when it comes to board action or positions on matters when it is not a board meeting? There was nothing in the notice of the annual meeting mailed about a board meeting on that particular date. Sometimes board members or even property managers say things to these few attending owners that may or may not be the outcome when the board actually takes it up as an issue. And the problems that arise down the road if action or no action is taken on whatever an owner brings up. So, to answer your question, generally speaking, and I don't know the specifics about what was discussed. We're just talking about the fact that there were things that were discussed. We don't recommend holding any board discussions outside of the open meeting requirement. We've been hammering that over and over, and we're going to continue to do that. There are very few exceptions to that rule. All meetings, including owner meetings, must be treated as open board meetings under the statutory requirements effective January 1st. That being said, so to clarify, board decisions are made in open meetings. Past actions, which you're talking about here in the second part of the question, are not considered board actions or board decisions, regardless of whether or not it was discussed in an open meeting. If you're just talking about things that happened in the past, that whether or not it was in compliance with the statutory requirements, those decisions were made, whatever decisions were made at a past meeting would not be considered actions of the board unless they were discussed and decided upon again in an open meeting at a later time. So, and then generally speaking, we don't see any reason why board members shouldn't engage in a discussion or answer questions about past actions with owners if there's some type of meeting taking place, but just know that whatever is said in that context would not be considered an official decision of the board. Ken, do you think that covers the question?
Well, I think so. If a person were to ask a question about how the board is going to address something in the future, then I think that the board should just say, we'll have to discuss that in a board meeting. But usually what I see happen is some well-meaning and concerned owners show up for the meeting, but you don't have a quorum. And the board or the manager essentially give a report about all the things that have gone in the past and maybe even the topics that might come up going forward. And I think that's appropriate. There would be no meeting minutes to reflect any of it because there would be no action taken by the community at the annual meeting because the annual meeting didn't get a quorum.
Yeah, and I would add the best thing to do is if those are topics that need to be discussed, I would add them to the agenda for the next scheduled open board meeting. And then that way, whatever was discussed at that session that wasn't official could become officially a discussion point at a future date.
That sounds reasonable. So the next question is, are there any RCW rules related to reasonable board nomination periods? So there's nothing in the statute about nomination periods. Okay, so there's not a definition of it. There's nothing that says you have a specific process for nominating. We certainly have seen a lot of governing documents, meaning bylaws or declarations, which might specify use of a nominating committee, and they might even specify timelines for when nominations can be collected or submitted. If you were doing an election by mail, sometimes there are really precise timelines that usually take somewhere in the order of 2 months to complete, where you would ask for nominations first, and then after that period of time, you would send out ballots, and it really depends on your particular documents. But I guess our short answer would be if your documents are silent, if you give notice to the membership that you're going to hold an annual meeting or a special meeting where you will conduct an election, you have to give at least the minimum 14 days notice required for that meeting. And I'd say in most circumstances, that 14 days would probably meet the reasonableness requirement of statute. A lot of governing documents require that you accept nominations from the floor at the annual meeting. So if you have told people more than 14 days in advance that you're holding an election, you could include in that you'll accept nominations from the floor. But yeah, anything you want to add, Tima?
No, I think Ken and I were just discussing that the statute repeatedly seems to assert that 14 to 50 days is the reasonable period of time. And so that's where, our position here as well. Um, the next question. A board member is insisting that once an item appears on the board agenda and the agenda is approved at the start of the meeting, any information on that item which was included in the budget packet for that meeting must now be discussed openly, and the item cannot be discussed in executive session. My understanding is that the board packet can and should be redacted of any sensitive information before being made available to non-board members, and that an executive session can be entered into at any point during the meeting to discuss any item on the agenda which meets the specific qualifications of an executive session after proper motion, second vote, etc. Am I off base here? The short answer is no, you are not off base. You are correct. While there is not any case law to interpret the statute yet, our position is that under the new statutory requirements, executive sessions may take place during otherwise open board meetings under the specific criteria which you reference here, and I will go over. An executive under 649442 2A, meetings must be open except during executive session. Executive session may be held only to conduct with consult with an association attorney concerning legal matters. 2, discuss existing or potential litigation, mediation, arbitration, or administrative proceedings. 3, to discuss labor or personnel matters. 4, to discuss contracts, leases, and other commercial transactions. And 5, which you reference here, specifically to prevent public knowledge of the matter to be discussed if the board or committee determines that public knowledge would violate the privacy of a person. So that being said, you also brought up the topic about what's included in the board packet. So we want to address that to say that just the fact that an item is placed on an agenda for the board meeting, there's two things to that. One, it doesn't require that it be discussed or acted upon in the meeting. Just because it's on the agenda doesn't mean A, that you'll have time to get to it, or B, that you will get to it, for example. The second point is regarding the agenda. You may start out a discussion on an agenda topic that is appropriate for open board meeting discussion. And then you may veer into one of these topics that I've covered, an existing, a potential litigation, or perhaps a privacy matter. And at that point, it's appropriate to move into executive session. That may not necessarily be something that's anticipated at the beginning of the meeting or specifically in the agenda itself. But just as this question is being posed, it is correct that there are points and times in which executive session is entirely appropriate. So, we want to make sure that that's clear, and also that when you are adding items to an agenda, material that's distributed to the board in advance of a meeting and is not intended for executive session, we would always suggest that an owner would be entitled to the same material before a board meeting. This would allow them to decide if they want to comment about the matter at the beginning of the open board meeting, as is required under the statute. I think that covers the question and the answers. Ken, did you have anything you wanted to add, or was there anything confusing about the way I worded that?
Well, the one thing I would add is that the last exception for holding an executive session is to prevent the public knowledge of something that would violate the privacy of a person. And this is a really vague provision. And it actually says that it is the board or the committee that determines whether the public knowledge would violate the privacy of the person. And I'm not exactly sure how or when the board is supposed to do that. I would assume that if a board member makes the motion to move it into executive session, that they might state it's because they want to not violate the privacy of any person involved. And then the board gets to decide whether or not they're going to move into executive session or not. So if someone is wanting to talk about a fence application and they a board member wants to argue that building a fence, which the ACC might regulate, is really about the privacy of a person, then they could make a motion to that effect. And presumably, if the board agreed, it would move into executive session. If the board did not agree that construction of a fence was going to violate anyone's privacy, then it would stay in the open meeting. And, this is a two-step process. It's, first you have to decide to go into the executive session, and then you would move into it and then come back out of the executive session in order to make any motion or document any decision or action being taken by the board. So you don't go into executive session and then secretly make a decision. You're required under the statute to come back into the open board meeting and to take the final action. You don't put the discussion into the action item which is being voted on, but you do put the action taken by the board. So this is one where I am certain we're going to see a lot of disagreement amongst owners as to whether or not things should be private or not private. It is going to sort of give one more thing that the boards have to try and exercise some discretion about, and they need to try and do that in a reasonable manner. I don't think that you could come up with a specific rule about what is or is not, because not only is it going to depend on the particular subject matter, it may also depend on the privacy perceptions of the people involved. So there may be some disputes between owners that the owners don't want it to be done in executive session. They want the discussion to be done in an open meeting. And I think that the preferences of the people involved would have to be considered when the board decides whether or not it would violate the privacy of a person. Any other thoughts on that, Kima?
I don't think so, Ken.
Okay. Well, that's the end of the ones that we had actually submitted in advance. So we would look to the chat if there are questions there. Chelsea, did you see anything?
First question from the chat. When the board meets in an executive session after the elections took place in an open meeting to decide officer roles and responsibilities, are the minutes of those meetings shared with the whole community?
So my first question would be, why would the board meet in executive session to select the officers? Because I don't think that that would qualify for any of the exceptions listed in the statute. But the next part is there are no meeting minutes kept for executive sessions because they're discussion only, and any action taken would be done in an open meeting. So even if the board were to meet in executive session to talk about who's going to be the president or secretary, the motion to appoint them as president or secretary has to be done in the open board meeting. Did I cover everything, Tama?
Yes.
All right. So next question. For the SB 5686 requirements, does the limitation of a maximum 5% late fee include separate interest charges? Many associations charge a late fee and a separate interest charge.
I assume this question is referring to the new requirements effective in January for collections and that initial period prior to referral. And I believe our position is still that it's a maximum of a 5% total. So that, if you have a late fee or you also have interest, you can't charge more. It has to be nothing more than 5% total. Ken, do you think I'm misunderstanding the question?
Well, I'm going to try and summarize, and you'll have to correct me on this, Tima, because you do it more. The new statute is basically stating that the association is required to send a pre-foreclosure notice within 30 days of a payment being missed. That's not 30 days from your your 10-day window for a late fee. It's 30 days from when it was due. And the statute says that until 15 days after you have sent that pre-foreclosure notice, you are not allowed to assess a late fee that is more than the smaller of $50 or 5% of the delinquent amount. And you are not allowed to assess any administrative fees for sending the letter or notice in excess of $10. So you basically are limited. I don't believe the statute references interest.
It doesn't.
And so I don't think that we would recommend that you also charge interest with that first month's or, the first late fee. But I think if you were to go into collections with an attorney 9 months later, that you would be able to follow the interest provisions in your governing documents, which would usually start the interest on the date which the payment was due. So I think that it would be incorrect. I would agree with Tima. Don't assess interest with the first late fee and when you send out the pre-foreclosure notice. But I think it is okay to assess the interest if you get into a enforcement action on collections later on. So I need your thoughts on this, Tima.
No, I agree, Ken. I think it's pretty clear here that it's a maximum of $50 or 50 or 5%, and interest is not mentioned. So that's, to answer your question, that's your limit. And then once all of those requirements are met, we go back to the normal collection process. This is only for that initial, what we call sort of intake period, and that's what we're looking at. Also know that, again, we don't have we don't have no case law yet interpreting these new rules, but as far as we are concerned, we are looking at these rules effective for delinquencies that began on or after January 1st, 2026. Just to, because we're starting to see new collection matters this month, and we're looking at them depending on when the delinquency started. And that also affects how we look at this intake process. So
Yeah, there are a lot of I sort of think of them as landmines that were created by this new legislature for collections actions. We know that most of our clients do not have collections policies which comply with the statute's requirements. And we know that most of the management companies have fee structures which would provide for the owner being assessed an administrative or management fee or some kind of late notice fee, which is in excess of what the statute allows. And those are creating problems because of the acts of the association or manager now violating the law. And then we have the additional problem of people who are not counting the time, because until you've mailed that pre-foreclosure notice and then waited an additional 15 days, you can't use your regular late fee and admin fee structure. And if I understand it correctly, if you waited 3 months to send out the pre-foreclosure notice, you're still only entitled to one late fee of not more than $50 or 5%. And so it's going to mean that a lot of collections matters are going to come into our office, and we're going to be telling our clients that we cannot collect much of what they have been trying to assess the owner in late fees, interest, and admin fees. Is that true, Tima?
right, if it hasn't met with the requirements that we're talking about for a delinquency that began on or after January 1, 2026. So if you are receiving new delinquencies now, those requirements apply to you now. And so in order to prevent what Ken is saying with this, this potential, loss of collections amounts, then, if you're following these procedures, that won't be an issue. But if you are sending us a delinquency in June that began in January, you will see that we will not be able to collect those amounts. So that's why we're hammering it now. If you have questions, please refer to your association attorney. If that's us, reach out to us. We will provide you with specific information exactly step by step. We have we've created some memos and cheat sheets for exactly this flow chart that we're talking about right now.
Yeah, and this does then raise questions for boards and managers about when do you send the pre-foreclosure notice? We've had some clients who want to send it on day 5 because they want to make sure that they can assess the late fee and admin fees as many times as possible. But we've other clients that don't send a delinquency notice till 30 days after. And if you don't send it till 30 days after, you're going to start limiting the number of late fees that you can send. And then there's the problem of the pre-foreclosure notice being really scary. And so if you're normally sending a fairly polite, hey, we missed your payment, can you please make sure that you check with your bank letter, including the pre-foreclosure notice is going to make some owners think you were trying to take their home from them because they were late on one payment by 15 days. And so there's going to be some confusion. It's going to be especially difficult for those owners who have English as a second language. And there's also then this new strange requirement that if an owner asks for the pre-foreclosure notice in the language of their choice, you're required to provide it. And we're not exactly sure how the legislature intended associations to do that. But it is a new requirement, is that you have to send the pre-foreclosure notice in a specific language if the owner requests it. It's just making the collections much harder.
And we're just at the beginning of this process ourselves. So as we continue to see new files referred to us, we are, making notes. We're noticing what discrepancies there are, what questions are coming up, and, we plan to, continue to advise our clients and those attendees of the Q&A to the extent that we are able to evaluate these discrepancies, pitfalls, shortcuts, whatever you may call them, and to hopefully over the next several months come up with some clear directives as to how these should be managed and handled.
And there's a good chance the legislature will change the rules again this session because they get a chance to change the laws every year. And we just started this session. So, anything else, Chelsea?
Yeah. If agenda items change prior to a meeting, but the meeting date, time, and location does not change, does the agenda need to be remailed to the owners prior to the meeting? If so, does that mailing also have to be at least 14 days in advance?
So I'll say that's a good question. And we
I'll let
don't
you take that,
know
Ken.
the actual answer. The statute was modified to allow for 7 days notice for something which should not reasonably be foreseen. And the statute says that with the 7 days notice, you have to send it to everybody's email address, which has been interpreted by at least some people to mean you still have to mail it with 7 days notice. And in addition, you must send it by email, even if they didn't ask for notice by email. From a practical standpoint, what we're seeing is a lot of clients put their agendas online and they are adjusting the agendas, up until a week or even 3 days before a meeting so that owners who care can be informed about what's going to be discussed at the meeting. But the vast majority of owners pay no attention to these agendas and the meetings. So it's one of these things where you're trying to balance the cost of strict compliance with the risk of what I might call reasonable compliance. And the circumstances will be different for different communities, and they might be different for different subject matters. So, for example, If you are looking to do a revision of your rules, I don't think that would be a safe thing to add to your agenda 3 days before the meeting. I think that's one that probably you should make sure has the 14 days notice. On the other hand, if you're looking to hire a roofing contractor to patch a leaky roof, and that got stuck on the agenda 3 days in advance, I think the risk is pretty low that anyone would challenge the board discussing and making a decision on that. So I think that there has to be um, some amount of reasonableness that you're going to be dealing with. And, one of the things which we'd written in one of our questions and didn't write down, but I'll find. Well, I'll just paraphrase. We think that, or we are encouraging our boards to try and substantially comply with the new laws. If you are intentionally avoiding the open meetings and the requirements of notice and acting in bad faith, I think you have some significant risk if someone challenges your actions. Now, of course, it may be no one challenges your actions, but if you are trying to comply and acting in good faith, and you were to have some new issue come up and you added it to the agenda 4 days in advance, I think that you're probably safe. And then there is an additional, kind of safe harbor written into the statute where even if you do not comply with all the statutory requirements, that a decision of the board is still binding unless it has been thrown out by a court. And the timeline for someone to bring a court action is 90 days from when that decision has been sort of published to your membership. So if the association were to enter into a contract and they had forgotten to give 14 days notice, but they published the board meeting minutes after they were approved, showing that the board had entered into the contract, then the members of the community would only have 90 days to challenge that. And if they didn't challenge it in 90 days, it would be a fully binding decision. So the legislature is who put this sort of safe harbor in. I don't know why, but it probably was to counter the oppressive requirements of these, the new notice and meeting requirements. We don't want people to rely on that safe harbor and avoid good faith efforts to provide notice and meet the requirements of giving the owners an opportunity to comment and observe what the board is doing. So, any other thoughts on that, Tima?
I mean, I would just say, generally speaking, even before the changes went into effect in January 1st, our advice has always been for our clients, for boards to have regular meetings. So, and now with this open board meeting requirement and the agenda requirement, it's not a bad idea to have a sort of a deadline for agenda items to be added and to advise owners that any agenda items that are received not after that deadline will be added to the next board meeting agenda. And if you have all of your board meetings scheduled in advance, which is generally a good idea and something we generally recommend if you're having monthly board meetings or every 6 to 8 weeks or whatever they are, then those agenda items are being added in a reasonable manner, in a timely manner, with the exception, of course, of the 7-day notice requirement for things that for that one exception, and that's a way to ensure that agenda items are being added, owners' voices are being heard, and you're also observing the requirements that are the laws in effect at this time. So if your concern is getting agenda is addressing agenda items, that is one way to handle it in order to be compliant with WUCIOA.
Anything else, Chelsea?
Next question. Did RCW 6490.515 notice take effect 1 5/1/6/26 along with the 6490/445 meetings. I'm looking to find support to send our annual meeting notice and packet by email.
So this is pertaining to the budget, and those budget so those laws went into effect in 2018. So nothing has changed as far as budget or the notice requirements.
Well, actually, did you say 515 or 525, Chelsea?
Oh, maybe I misunderstood.
5/1/5.
Oh, 515.
Well, 515 did not take effect for any pre-existing communities on January 1, and it did not take effect when the statute was adopted. But I would also answer that under all of the statutes, the ability to send notice electronically to owners who opted in was inserted. So that's in your current statute, but you cannot require owners to accept email notice. So if you think a new statute's going to let you send email notice and avoid mailing paper copies, you're just wrong. The ability to send it to owners who agree in advance exists in your current statute, and it's in WUCIOA. There is no ability to avoid mailing it to an owner if they did not agree to accept electronic notice.
All right.
Anything else?
The period to nominate a board member ended. However, manager allowed additional nomination after this period. Do we need to have a new election?
I'm going to say that's way too fact specific, and I'd have a lot of questions. We can't answer that one.
Okay. Um, this was more of a statement than a question, but you guys might want to comment on it. I read 6490/445/9C. Incumbents or other candidates on the ballot may not possess or be given access to ballots to mean that they may not collect ballots, no possession regardless of whether or not they are in a sealed envelope.
Well, I think if the person's collecting the ballot and it's in a sealed envelope, I'm not sure how they would have the information about the ballot. There's probably something else going on that I don't know about, so I'm going to say that's another one. We can't give you legal advice on this. I think that cited section of the statute it is intended that a person on the ballot is not counting the votes and reporting the results. And whether or not the ballot was sent into a post office box and the board member brought the ballot from the post office box to the meeting to count the ballots or not, I don't think that would invalidate the process. And also, when we start getting into these questions about the ballots, I always want to know whether or not the particular ballots that someone is challenging would make a difference. Because if someone is winning by a vote of 20-5 and someone starts questioning the ballots because a board member possessed the sealed envelope with one of the 20 votes, I would say, well, what's the result if you take away the contested ballots? If it's the same result, then what's the point of challenging it? Most of the elections we have, most of the votes for things like budget ratifications are not close in terms of the voting.
All right.
Anything else?
There's one last one. Um, Question RE, owner's right to review records. In our declaration, there's a list of protected records that are exempt from owner review, one of which is individual unit files other than those of the requesting owner. Does case law define or describe what these individual unit files may consist of? Should this include all records, maintenance records, floor plan, building plans, or build specifics about a unit, or only sensitive information like owner details, financials, etc.?
I believe the language that you read out is exactly what the current statute says. We have seen no cases come up through the courts yet which have described what would be considered appropriate. We've also not seen a court decide what it means to redact the information, because sometimes you could provide, like an ACC request and redact the information for the individual unit without providing sensitive incident information. We usually lean towards withholding more based on a vague statute, and then seeing if the person requesting challenges that. And it might depend on the purpose. So again, a lot of these questions start to be very fact specific, and the language of the declaration is going to have to be interpreted based on the facts and circumstances involved.
All right,
So that
that's all
sounds
I've
like,
got.
all right. Well, thank you everyone for attending, and I guess we'll see some of you next week. Thank
Thank
you.
you. Have a great day.